Good morning everyone, welcome to our webinar on coronavirus and returning to work, which we're running in conjunction with our partners Hayes, and Matthew and Simon are sending a virtual wave to everyone on the webinar this morning. Today's webinar will be hosted by myself. I'm Sarah Burke, I'm a Senior Associate in the Employment team at Irwin Mitchell, and also my colleague Laura Ludlam, who is a solicitor in the Employment team at Irwin Mitchell. Just in terms of a couple of housekeeping points before we commence, there will be a feedback form for you guys to complete. There will be a link posted to that a few times during the session in the question and answer box at the side of your screen. So if you could fill that in, that would be greatly appreciated. We love to hear from you, love to hear your feedback, and also to know what you'd like for future events, etc. So it's really helpful for us in shaping these events. Also, just in terms of some housekeeping, please ask questions throughout the event. We know it's not quite the same as seeing us in person and being in our offices, but please do ask questions. The way to do that again is via the question and answer box that's at the side of your screen. Please ask those. We will probably be doing a question and answer section towards the end of the webinar, going through a lot of those questions with you and any particular points that you'd like to cover. And also, just to let you know, this is being recorded. And so we will ensure that we send it out after the event so that you've got the recording and for any colleagues who are unable to attend. Fantastic. So if we move on to our first slide. So looking at the back to work timeline for the recovery strategy that the government had put in place. Obviously, everyone is aware of that. 23rd of March, we went into national lockdown. Many businesses had to close their doors. Obviously, not all businesses, some essential businesses such as supermarkets, hospitals, etc., are allowed to continue. But many businesses and many clients that we were working with obviously found themselves in a difficult position of needing to close. 13th of May, we had the announcement of the UK actively being encouraged to return to work if they couldn't work from home, and workplaces were starting to open. That, of course, caused quite a lot of panic and concern amongst employers, ensuring that they were ready for that and ensuring that they were supporting their staff and keeping them safe. We then had the 1st of June, where schools and colleges were encouraged to open for some pupils, and obviously we're seeing a lot of that at the moment and a lot of the conversations and queries around that. And then 1st of June, obviously the outdoor markets and car showrooms opening, and then other non-essential shops looking to open from the 15th of June onwards. We're obviously hearing dates for July as well, in terms of then maybe restaurants, pubs, other parts of sectors being able to reopen, and that's definitely one to watch the space at the moment as to whether or not that will happen, because that will largely depend on us continuing to meet those government 5 tests, and particularly keeping that R rate down. So definitely one to look out for. But we're seeing lots of kind of commentary in terms of restaurants and pubs, children's play areas, soft play, those types of areas probably likely to be the later things to open, largely because they have the most contact with people. So moving on to the next slide. So what do? The government has announced that you're going to be able to potentially reopen your workplace. I know from some of my clients that sent a bit of mass panic as to how to deal with that situation and how to get ready for that. So if we just go back to the previous slide, fantastic. So in order to open your workplace, it must be COVID secure. It's a bit of a new buzzword. We've had lots of new buzzwords introduced during this coronavirus pandemic. What does that actually mean? As an employer, even before coronavirus hit, you have a duty to take all reasonable steps to ensure that your staff in your work environment and your workplace are safe, and you are to identify risks to them and take steps to reduce those risks to the lowest practicable level. So note, that isn't eliminating them altogether. That would be entirely difficult to eliminate any risk to anyone, but ensuring that any levels of risk that you have are the lowest practical level that you can get them to. What are the minimum steps you have to take? Well, I'm not a health and safety expert, but the Health and Safety Executive has set out some quite good guidance in respect of how to deal with this, and also the government has put out some sector specific guidance. The Health and Safety Risk Assessment guidance from the Health and Safety Executive is quite simple in terms of the plan for your risk assessment. So you need to identify what work activity or situations you've got that might cause transmission of the virus. So if you've got lots of people working together in close proximity, doing particular roles, that's clearly going to be a risk area that you need to look at. You then need to go further. Who could be at risk? And that's really one to watch the space in terms of the government guidance. As you will have seen, although it's not been added to the government guidance yet, but there are papers and discussions around how actually this virus, this horrible virus, seems to be massively impacting the Black, Asian and minority ethnic individuals. So that's one to watch out for, because potentially that could be added to people who are in that vulnerable group. Recently, the government actually also included severely obese employees. So they were suggesting that individuals with a BMI of 40% or 40 plus potentially are more risk of suffering quite badly from the virus as well. So actually keeping an eye on that when you're carrying out your risk assessments and updating those as that position changes, because it may be that the vulnerable groups of people that we had previously might start to change. But so identifying who could be at risk, and then deciding how likely it is that someone is going to be exposed. Again, if they're working in close proximity to each other, that's going to be a bigger risk than if people are, definitely more than 2 meters apart and quite spaced out. And you, as a business and an employer, have to act to remove that activity or situation as an initial point. If you can't do that, that's not possible, it's not practicable, then you need to try and control that risk as far as possible. The government guidance that's been issued, as I've said, the sector-specific guidance, although largely it follows a similar sort of pattern in terms of what to look at, what to be careful about, and how to implement a plan in returning to work. But there are some sector-specific points in there. The basic rules that come out from that sector guidance is that if you have to have people back to work, do so. If you can maintain social distancing, then that should be okay. If it's not possible, though, you can only reopen and have people back in your workplace if you can put in place suitable measures to control the risk of transmission. How are you going to do that? Well, that might include putting barriers in shared spaces, creating shift patterns so that you don't have the same workers, or you don't have lots of workers coming in, but you have bubbles of workers. In the education sector, people probably will have seen bubbles of children to ensure that they're acting more like a household, as opposed to having lots of different people mixing with each other. So actually, can you have some shift patterns so at least it's the same people coming into contact, rather than ending up with a situation where someone ends up with symptoms and having to actually ask most of your workforce to stay away and to isolate. Also think about shared spaces. If you've got shared spaces with other businesses, for example, you may need to be talking to your landlords, etc., about how you can, again, try and minimise and limit the amount of people that are coming into contact with your employees. So again, something to consider. There's been lots of examples of how businesses are doing this really, really well. The supermarkets, to a large extent, obviously have managed to remain open throughout the whole of this because they needed to. People needed food, but they have done really well in terms of putting barriers at the tills and putting in place one-way systems, limiting the number of people who can enter the shop at one time, limiting even the numbers of people that can actually come together and shop. So some really good examples out there, and I think definitely looking at peer organisations and what other organisations are doing in respect of putting in place those measures, but also thinking what's right for your business and your staff to try and limit this nasty virus and it being contagious as much as possible. Really important to consider things carefully. Make sure you consider that this isn't something you do in 5 minutes. This needs to be a proper plan, your risk assessment, and also make sure that you are documenting the steps that you've taken, not just the end result of your risk assessment, but you're documenting the steps that you've taken in coming to the conclusion on that risk assessment, because that will be really helpful in demonstrating that you've considered these issues. So you've got your risk assessment, you started putting that together. What else do you need to think about? Consultation. There are 2 sets of general regulations that are likely to apply here in terms of health and safety. And they are designed to help an organisation develop, maintain and promote measures that ensure health and safety at work, and also to check how effective they are. If you recognise a union or part of your workforce is unionised, then you will need to collectively consult with that union or a health and safety representative of that union, and that typically would be done under the second regulations, the safety representatives and safety committee regulations. If you don't have union representatives, you don't have a unionised workforce in place, you could think about introducing one. That's going to take some time. The alternative is that you'll need to consult with your employees, either directly as individuals or through a workforce selected health and safety representatives, which would obviously involve electing people and putting in place those people. But the important point to note is you need to be consulting with your staff or representatives before they come back to work. You might even have to consult under both sets of regulations. There are many businesses out there where part of their workforce are unionised and maybe part of the other part of the workforce isn't. And so, again, this is why it's key that you are taking steps and planning, even if you're not quite sure when you'll be able to open your business yet, to start thinking about this and planning now, because it's not something that can necessarily be done quickly, and you'll want to ensure that you are getting things right. So more just around what that consultation would look like and timing. Consultation, as hopefully everyone is aware, involves giving information and taking into account what they say before making those decisions. So before you make health and safety decisions, before you just decide to go ahead with something, really listening to what people have got to say. Coronavirus has really hit people badly. People are really scared about it, understandably, but equally as businesses we need to return to work. We need to move the economy along and look after our staff. But really listening to what people have got to say, I think, will ultimately help in smoothing out this process of people returning. The law, unfortunately, doesn't actually state when you must consult or how long for, but it does say it should be in good time. Doing this last minute, a few days before people return to work, is not probably going to be in good time. So again, this is why planning and getting this in place now, even if you're not sure when you'll be returning to your offices or your premises, is really, really key. Really important to note that consultation doesn't actually remove your right as a business, as an employer, to manage, and you're responsible for making the final decision. So it's not a case that if people are unhappy, you have to just bend over backwards and say, well, that's fine, we won't ever open again, because that wouldn't be appropriate. You do have the final decision, but you have to make that with the knowledge of what your staff are concerned about and having ensured that you've gone through that health and safety process and those risk assessments. Whilst you're responsible for making the final decision, if you do recognise a union and you're unionised, obviously they have more clout in that if they don't agree that it's safe for workers to return to work, they can obviously ballot their members and take strike action if there's sufficient numbers. So where you are unionised, really getting those unions and staff on board will be key, I think, in terms of ensuring that you can return to the workplace. Why is it important to ensure that you comply with these health and safety regulations? Well, one, to look after your staff, look after you, look after your business. But secondly, if you don't, you'll be committing an offence. Health and safety inspectors from the Health and Safety Executive and also local authorities can enforce the regulations, particularly where there's no evidence of consultation. They can issue sanctions, so they can really force you to do this, and that's not a great position to be in. So really, really important that you are doing this before your staff are coming back to the workplace. So what about people travelling to work? So employers don't normally have to factor in travelling to work as part of their risk assessment. How staff get to work is their own business and pretty much for them. However, we've seen pictures in the news, etc., of crowded buses and tubes in certain areas, and it's clear that social distancing is going to be really difficult for those using public transport. Obviously, people are being encouraged not to use public transport, and if they do, to ensure that they are using PPE, they're wearing face masks. Only so many people are allowed on at a time. We've seen the rail companies reporting that the days of people standing up and cramming in as many as possible are likely to be over for a significant amount of time, with a very small number of people being allowed on trains, etc. So we think that now, bearing in mind the current world that we're living in, it probably is necessary for an employer to factor in how their staff are going to travel to the premises. You need your staff back at work. How are they going to get there? The health and there's probably, before I move on to the health and safety legislation, there's 4 key legal responsibilities as to why you want to do that. 1, health and safety legislation we think now requires you to do so. 2, you have a common law duty of care to your staff. That's that duty to look after them, make sure that you're not exposing them to harm. 3, a duty of trust and confidence. If you breach that duty of trust and confidence, it can result in claims of constructive unfair dismissal from staff. And this is a tricky area that's unprecedented. We don't know how tribunals will react. So again, really, really key to try and ensure that you're working with staff. The other reason to do this, and for the 4th legal responsibility, is the duty not to subject employees to a detriment or dismiss them for taking evasive action over serious or imminent danger. And this is, again, an unprecedented area where people probably are quite concerned about the dangers at the moment. So lots of good reasons there as a business why you will want to ensure you're doing this. The health and safety guidance in terms of travel and building that into your risk assessments is actually quite limited, and it simply says an employer should think about, and then it goes on as to what you should think about, and it says you should think about identifying where people can travel alone in their own transport, or walk or cycle, because that's likely to be the best thing for them to do, and to make sure obviously that when they're in work they're then social distancing. Even if people are walking, cycling, driving their own car, you're also going to want to think about staggering arrival and departure times so that everyone's not arriving together. You can keep that social distancing when they do arrive, and distancing rules around, do you have one entry point, one exit points? They're providing hand washing facilities or hand sanitizer at those entry and exit points to ensure that people are hand sanitizing and making sure their hands are clean when they're coming in. And having rules around people washing their hands frequently and using hand sanitizers for any entrance or exits or doors that they use. That's what the health and safety guidance says in terms of what you should think about. Our view is that you probably should go further than that because of those 4 legal tests. It's not just about the health and safety law, it's about those other tests, that you should probably go further. So anyone who can't walk, cycle or drive work is likely to need to use public transport. If it's overcrowded, there's going to be a risk that they may not even be allowed to get on it if it's likely to be overcrowded. The government's published some safer travel guidance for passengers, which is helpful, and it does ask users to consider all forms of public transport, and if there isn't alternatives, to think about travelling off peak, wearing face coverings, obviously avoiding eating and drinking, etc. So these are all things you will probably need to factor in the advice that you're giving to staff if you are requiring them to come back to the physical premises. Options for dealing with that, that's a bit of a minefield. You've got lots of people coming from everywhere. How are you actually going to deal with that? Well, find out first of all how staff travel to work and how they're planning on travel to work, and if they've got particular concerns. Only ask those who are willing and able to attend the workplace to do so if possible. So if actually you can keep people working at home, that's probably the safer thing at the moment. Assess each employee's situation individually as well, taking into account their commute, general health, maybe people they're living with, if they're living with vulnerable or people that are shielding, and just seeing if there are other ways that you can try and support them in returning to work. A lot of this is just being sensible and trying to limit the risk to staff as much as possible. And I think if, as an employer, you approach this as you want to listen to staff, you want to be fair, you want to be reasonable, and working together, hopefully everyone's aim is to get back to a place where they can work and work easily. So really kind of, joining up with your staff to do that. Briefly touched on earlier, when you're doing your risk assessments, considering whether it's safe for different groups of people to return. So vulnerable people, so that's not those that are highly at risk and those that are shielding, but vulnerable people as per the government's list, which frequently changes, but include, for instance, over 70s, those with some underlying health conditions. It now includes the government say as obese employees, those with a BMI over 40. And it doesn't currently handle Black, Asian and minority ethnic employees, but we think it's likely that that will be updated and it will be covered. So when you're looking at your risk assessments, you may actually need to either do separate risk assessments or really identify sections for those people where they're more at risk, and make sure that you are considering those, because they will be at greater risk than maybe someone who is fit, healthy and doesn't fall within the government's guidance around vulnerable people. Pregnant women are also on there, and obviously being careful around vulnerable pregnant women. The other thing to note with pregnant women is you don't just need to think about this from a health and safety perspective in terms of COVID. Pregnant women have always had special rights. The moment an employee tells you that they are pregnant, there are certain things you have to do in terms of risk assessments for them, and potentially then looking at changing their work if there is still a risk present, or potentially even suspending on full pay if you can't minimise that risk. So it's important to note that for pregnant women in particular, you will need to think about other legal obligations that you have in respect to them, and again just making sure that you're being careful in those areas. It's an area where you're going to have to be quite tactful. There are, if people have underlying health conditions, they're likely to be disabled. So you need to be careful around discrimination. Pregnant employees, you'll need to be careful around discrimination. If we're starting to look at Black, Asian and minority ethnic as being, massively impacted by this, again, you just need to be careful in terms of any sort of discrimination risk and making sure that you're treating staff fairly and appropriately in accordance with the government's guidance. Anyone who is shielding must still remain at home. And so that either means at home working if they can, and again if your staff can work from home at the moment and continue to do so, that might be sensible in the interim. Anyone who's shielding who can't work from home, then you're going to have to continue with what you have been doing in terms of furlough while that is still available, sick pay or some other sort of leave as to what you agree with them, but forcing people who are shielding to go back to the workplace wouldn't be appropriate at this time. So then I'm now going to pass over to Laura, who's going to talk a little bit about the future and how we move ahead, bearing in mind the situation we're currently in, dealing with furlough, and also looking at what happens if staff aren't agreeing to come back to work. How do you run your business in the current situation?
Thank you, Sarah. So as Sarah mentioned, we're going to, in the next portion of the presentation, going to be looking at the kind of things you'll need to be considering over the coming months. So unless your business is in a very fortunate position, you're likely to need to reduce or continue to reduce payroll costs while you assess what your organisation is likely to look like over the next weeks and months. So ultimately, if you aren't going to need as many people as before, then the main options are as set out on the slide. And we're going to look at some of these in more detail. So an announcement was made by the government on the 29th of May regarding the furlough scheme. And that was following a number of previous announcements. But this one was quite significant because there were a couple of key points which set out how the scheme is due to change. So the first key point is that the coronavirus job retention scheme will close to new entrants on the 30th of June 2020. So that means from the 30th of June onwards, employers will only be able to furlough employees who they have previously furloughed prior to the 30th of June for the required 3-week period. And further clarification on this point is still required, but it appears that as long as the employer has furloughed the employee for the required 3-week period at some point between the 1st of March and the 30th of June, they will then be able to re-furlough that employee after the 30th of June, even if that employee has returned to work and is not furloughed as at the 30th of June. So they just need to have been furloughed for the required 3-week period at some point between the 1st of March and the 30th of June. However, the cut-off date is significant because it means that if you have not already furloughed a member of staff that you might want to furlough in the future, You have up until the 10th of June, so tomorrow, to do so, in order for the required 3-week furlough period to be completed by the 30th of June. So that's quite significant there. So employers might be needing to take quite quick steps if they want to furlough employees now that haven't been furloughed before. Another key point in the government's announcement was that from the 1st of July 2020, employees who can't return to their normal working hours yet because, for example, there's not enough work for them to do, will be able to return to work for part of their contractual hours, but remain furloughed for the other parts of their contractual hours. So, for example, if you've got an employee who usually works 5 days a week, they could return to work for 2 days a week and then be furloughed for the remaining 3 days a week. And that's from the 1st of July. And this is good news for employers because it gives you the option of reintroducing staff to the workplace. But it's important to note that the employee will have to agree to that change, just like they had to agree to be put on furlough initially. Another point, which was detailed in the government's announcement, was that from the 1st of August, employers will need to contribute towards their employees' pay, and that's their furloughed employees' pay. And that contribution increases in stages up until the end of the furlough scheme. And those stages are set out on the slide. So for businesses, this is going to be quite a significant change to the scheme. And it will be really important to consider whether those contributions are affordable, and if so, for how long. And if not, are you likely to need to consider making redundancies? And should you consider starting that process sooner rather than later? And thinking about timeframes for a redundancy process is particularly important if you're intending to make 20 or more redundancies, because then the specific timeframes and the other obligations required under the collective consultation rules will kick in. And Sarah's just going to touch upon collective consultation a bit later in the webinar. So in terms of asking staff to return to work, unless the furlough agreement between you and the employee in question specifies that you will give a certain amount of notice when asking them to return to work, or that has been expressly agreed elsewhere, notice should be reasonable. So obviously that's quite a vague word, and the kind of things that you need to be doing is giving employees as much notice as possible. They might need to make arrangements, for example, for childcare, because schools are not currently open to all children, and the rate at which they're opening varies. Or the employee might have obtained another job while they're on furlough with you, so for example in a local supermarket to help out with the current increased demand, and they might need to give notice to their other employer. And it's also important to ensure that you give employees enough time to raise any queries or concerns, and for you to try and address those as far as you can. And when you're asking employees to return to work, we do recommend that certain points are covered in the communication between you and the employee. And we've helped businesses draft letters. So if that's something that you're intending to do and you need some assistance with that communication, please do let us know. But in terms of asking staff to return, there are going to be many people who are understandably worried about returning to work. And there are a lot of people at present who are worried about a second wave of the virus as things are kind of gradually easing in terms of the lockdown. And you know, the employee may simply be concerned about it, worried about it, or there might be a reason behind their concerns. So they might be a vulnerable person, their partner might be a vulnerable person, there might be childcare issues that are coming into play. And a track and trace system was supposed to be in place from the 28th of May, but the local infrastructure to support that is not yet up and running, and that's expected to take another couple of weeks or so before it's properly functional. So even then, it's going to rely on the cooperation of the public at a time when the trust in the government is not particularly high. So the effectiveness of that is kind of yet to be seen, but hopefully it's something that might provide people with a bit of reassurance. But where an employee doesn't want to return to work, the first step is really to find out why. So they might have been working from home. They might want to know why they can't continue to do so, and you'll need to kind of explore whether there is a justifiable reason why they can't. And as Sarah mentioned, risk assessments should be addressing risk to staff generally and specifically in terms of those considered to be at greater risk in particular. And in that respect, the government guidance should be taken into account in terms of the clinically vulnerable people, clinically extremely vulnerable people and their household members. So just by way of brief summary, in terms of clinically extremely vulnerable people, at the moment, the guidance is that they should continue to shield up until the 30th of June. Clinically vulnerable people are recommended to stay at home as much as possible. And if they do go out, take particular care to minimise contact with others outside their household. And if they can't work from home, they should be offered the safest possible on-site roles, enabling them to stay at least 2 metres away from others. But ultimately, it's going to be important to consider the specific facts in question and the specific risks in question as well, for example, discrimination. The simplest option is to try and agree the arrangements with the employee. So if they're asking for something reasonable arrangements, reasonable adjustments, then likely it's best to agree. But if they're not asking for something reasonable and agreement just can't be reached, then we recommend that you take advice on the other options. So for example, furlough, unpaid leave, etc. Dismissing them will generally be a last resort, but depending on the circumstances, you might be able to do this fairly. And that's what we'll move on to talk about in the next slide. But it's just important to note that you have to be very careful when thinking about that, because the employees are likely to have a number of rights and protections under employment law. So, as I mentioned, some of the rights and protections set out in terms of the employment law surrounding employees who refuse to return to work can be found under sections 44 and 100 of the Employment Rights Act. And under these sections, employees and possibly the wider group of workers are protected from being subjected to a detriment. So that could include, for example, being suspended, having their pay deducted, or being dismissed for refusal to return to work for health and safety reasons. And if the employer breaches these rights of the employee not to be subjected to a detriment in those circumstances, then it'll be an automatic unfair dismissal, which means that the employee doesn't need the qualifying 2-year period to bring the unfair dismissal claim, and the compensation that they could be awarded by the tribunal is uncapped. So that's unlike normal unfair dismissal claims where there are caps on the compensation. And the individual could also resign and claim constructive unfair dismissal if they haven't been dismissed, but if they've been subjected to another detriment, say, for example, having their pay deducted. So the test that we need to look at here is, in the circumstances of danger, which the employee reasonably believed to be serious and imminent, which they could not reasonably have been expected to avert, they left or proposed to leave the workplace, or while the danger persisted, they refused to return to the workplace or part of the workplace. And we'll just move on to consider that test in a little bit more detail. So to be protected, the employee must have a reasonable belief that their workplace poses a serious and imminent threat to them or to others, so for example, members of the public or their own families. And it's the employee's belief here that's relevant and not the employer's opinion. coronavirus is potentially a deadly disease, and so it is very possible that an employee could argue that it poses a serious and imminent threat, especially if, for example, they are a vulnerable person, they are living with a vulnerable person, if they have to get public transport to work, or if there are lots of employees in the workplace. However, as I just mentioned, one of the aspects of the test is that the employee is only protected if they could not reasonably have been expected to avert the danger. And this is where risk assessments, COVID-19 and return to work policies, social distancing measures, cleaning arrangements, PPE, etc., all come into play in terms of ascertaining whether the employer has taken reasonable and appropriate steps to allow the employee to avert the danger. So the more you can do to communicate with your staff about the measures you're taking, to reassure them of the precautions in place, and to make adjustments in response to their concerns, the better in this respect. And ultimately, we don't know how the employment tribunals are going to interpret the legislation because it's an unprecedented area in terms of COVID-19. So it's a watch this space situation. But in the meantime, what we can do is use case law from other contexts in respect of this test to guide us as far as we can in terms of how the tribunals might deal with this kind of thing in terms of coronavirus. So I'll pass back over to you, Sarah.
Brilliant, fantastic. So you've got people coming back to work, or maybe they're not. You're actually looking at making some changes to terms and conditions. And how do you go about doing that? We've had lots of questions from clients around this during the process, even just in terms of looking at furlough, or where people haven't furloughed, they've needed to make changes to terms and conditions. So what do you need to do if you need to make these changes? Well, first of all, the starting point is to identify what changes you actually need to make, and be really clear. Again, a lot of this is about planning. Let's not think about one particular part of the business for now. Let's look at the whole business as and when we can, but if we can do that as a bigger picture, do that. The next really key point is, do you have an express contractual right to make the change? There's some ACAS guidance around this, lots of case law around this, and ultimately you'll be wanting to check your clause wording to see what you can specifically change, whether you need to give notice, and if there is a process to follow. If you are relying on a clause in a contract that seeks to suggest you can make a change, for instance, 2 hours or days of work or place of work, it has to be, in order to rely on that clause to make a change, it has to be unambiguous and clear. And that's because tribunals and courts will always find in favour of the weaker party, if you like. So in terms of employment contracts, they will always find in favour of the employee because they were the weaker bargaining position. Any ambiguity, therefore, will be interpreted against you, and that's what you don't want. So general flexibility clauses, we still see them, they're still useful to sometimes put in, but a general clause at the end that says we can make changes and we'll notify you and give you notice. If you're wanting to change someone's hours, change their days, change their pay, that's unlikely to be sufficient to permit that change expressly in your contract. If you're not sure, definitely worth getting some advice around whether you can make the change, because sometimes the wording in the clause can suggest you can make a change, but if it's not really clear and unambiguous, it can still be a risk. Even if you've got some brilliant clause in your contract that says we can change your hours of work and we can flex them up and down, fantastic, that's first hurdle hit. Or you can move their location, you can move where they work to another closer location. That would mean you unilaterally could impose that. So you can say, I've got a right to do this under the contract and I'm going to take this action. You'd need to give notice, and you also need to be reasonable. All clauses in contracts have to be used reasonably. What does that mean? Well, it usually means that you need to give some notice of it. You can't just say, by the way, tomorrow you'll be working somewhere else. And also taking into account employees' particular circumstances. So particularly when you're looking at things like changes of workplace and maybe moving people to work somewhere else, thinking about what the impact of that could be. If they've got childcare responsibilities, etc., there could be indirect discrimination claims. So being really careful there. It will also depend on what changes you want to make, but fundamentally, if you get making changes to terms and conditions wrong and you don't deal with it appropriately, the risks are breach of contract, constructive unfair dismissal claims, and possible indirect discrimination claims. So moving on to kind of look at what do you do if you haven't got that contractual right to vary. So unless you're obliged to collectively consult, your first starting point is to seek individual agreement with staff. Consultation, again, is a two-way process, explaining the reasons behind the change, inviting employers to talk about concerns, listening to them, and then trying to reach some sort of agreement. If you can agree changes, fantastic. Record those, confirm them in writing. You might even need to send them a new contract in accordance with the new Section 1 requirements, but get that recorded in writing. If you can't agree it, what are your options? Your options are to unilaterally impose and just go ahead with it. That's always our last resort, because ultimately there are lots of actions an employer can take. They can stand and sue you, so they can carry on working for you and sue you. They can keep you to the old contract while they're doing that. They can resign, claim constructive unfair dismissal and breach of contract. It's not a great option, and definitely take some advice before doing that. The alternative is to look at dismissing and re-engaging them on the new terms. That still isn't entirely risk-free. You are dismissing someone. So ultimately, if they have more than 2 years service, they will have protection against unfair dismissal. And typically, you will need to ensure that you've gone through quite a process before you actually look at dismissing and re-engaging. And that would include your consultation process in trying to agree the changes, but also making it clear to staff that there is a possibility you may need to dismiss and re-engage. And tribunals will ultimately look at what you've done. Have you done everything you can to try and reach agreement first? Are the changes really necessary? You know, what's the risk of legal action, etc. If you do get to the point you've got this business reason, you really need to actually make this cut, you need to cut hours, otherwise the business is going to fold, then you still need to go through a fair process. So you need to follow a fair process in terms of dismissing them. You'd need to give them sufficient notice, statutory or contractual if that's more, and you'd also need to give them a right to appeal against the decision. And you'd need to be very careful around the timing of making the new offer. Typically that's either before you dismiss them or at the same time. And the tone of that communication is going to need to be really, really careful. So just make sure that you're dealing with that. It's always an area we suggest taking advice. We've advised quite a lot of clients in respect of dealing with this to try and minimise risk and to make the process as smooth as possible. Because if you get it wrong, it can really come back to bite you quite significantly. Just in terms of questions, we've got lots of fantastic questions coming in and we will be getting to those, but please keep asking questions throughout and we'll get to as many as we can towards the end of the session. So please don't hold off on asking and please ensure they're coming through because we've got lots of great ones coming through. So if you're changing terms and conditions, another thing that you need to bear in mind is collective consultation. So if we can move on to the next slide. The duty to collectively consult arises where the employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. When you're looking at collective consultation, often people wrongly think that it's just around redundancies. And yes, it's around redundancies, completely that is right, but it's not only in respect of redundancies. The rules around collective consultation actually say that they're in the context, and the context of dismissal means for any reason or reasons not related to the individual concerned. So that definition therefore actually can capture where you're making changes to terms and conditions. And apologies, I think we're just having a few issues with the slides moving on, but hopefully they will catch up shortly and I'll just keep talking you through the collective consultation points. You have to be really careful because dismissal and re-engagement can actually trigger collective consultation. So when you're embarking on a process to look at changing terms and conditions, what you really need to be thinking about at the outset is what happens if people don't agree? If they don't agree, is there a chance that we may need to unilaterally impose, and that might have negative connotations, and people might resign, or is there a chance that we may actually need to dismiss and re-engage? And if the answer to that is yes, and you are looking at this impacting 20 or more people, then there may be scope to start that collective consultation. it's one of those areas where it's quite technical, and there are various arguments as to whether you should start that or not when you first start talking about changes to terms and conditions. And it's an area where we've helped many employers just in terms of working out the best course of action and when to commence that process. So we're here to help if anyone needs to start thinking about that. But what I would say is, if you are going to be looking at making changes to terms and conditions, and those changes to terms and conditions could impact 20 or more people, or wider business reorganisations then bring in other numbers, it's probably really sensible to get some advice there on how you handle that process, just to minimise the risk, because the risk of failing to deal with collective consultation is potentially awards of up to 90 days pay per employee, not capped at any particular weekly pay. But there's also criminal penalties for failure to notify Secretary of State that you'll be going through collective consultation. They can be quite hefty fines, etc., which are, that is not what businesses need at the moment. So being really, really careful around that. If we can move on to the next slide, just to look at some problem areas in terms of collective consultation in the current situation. In the current situation that we've got, normally employees would be at work. If you needed to collectively consult, you'd be able to do that whilst they were at work. However, we're in a world where people are working from home, people are furloughed. How do you deal with collective consultation? Well, consultation collectively can't begin until you've got representatives in place. If you recognise a union, you're obviously going to need to collectively consult with them. And if you don't recognise a union, you're going to need to individually consult. And I think we're still slightly catching up with the slides a little bit, but if you bear with us, hopefully they will catch up shortly. In terms of, therefore, so what do you do? Difficulties are going to arise where you haven't got elected representatives. If you've got unions in place, it may be a slightly easier process to deal with. But if you haven't got unions in place, then you're going to need to collectively consult with elected employee representatives. How are you going to elect them if they're not at work? They may be working from home, they may be not working from home, they may be furloughed. The law in this respect requires you to make such arrangements for election as is reasonably practical to ensure election is fair, and as far as reasonably practical to ensure that the voting should be in secret and the election conducted to ensure votes are accurately counted. There's lots in this, so again, we're really happy to talk to people how to deal with this, because we probably don't have enough time to cover all of it today. But ultimately, you're going to need to think about maybe third parties holding the elections for you so that they can be in secret. If you can't do that, maybe thinking about having maybe one person in your HR team who's responsible for it, and they're the only person who see the names and who's voted, etc., to try and keep that to one person. If you're looking at collective consultation, the key thing I would say is to plan your process and what you're proposing to do and how you're proposing to do it, and to speak to staff about that and make sure that everyone is on board as to what your plan is, because it's far better to understand if people are going to kick off about your process at the start than for halfway through a technicality to be brought up that throws your whole process off completely, meaning you might have to restart again or you're at risk of claims. And just kind of thinking outside the box in terms of how you do it, you'll need to ensure a longer period of time. You're probably going to need to consult for longer because it's going to take staff longer to receive things by post, etc. How are you going to consult? Are you going to do it via video conferencing? If so, do your staff and the employee representatives have access to video conferencing? If people are on furlough and not working, they may not have laptops at home, they may not be able to join those. So you're going to need to have a clear plan as to who you need to consult with, what access they need, and then how you're going to be able to consult. If you're doing video or telephone conferencing, I would say thinking about having shorter, more frequent meetings, which normally you probably wouldn't do. You'd have longer and slightly less of them. Video conferencing and telephone calls, if they get heated debates, and these types of calls can sometimes get a bit heated, or people talking over each other, having shorter calls and more frequently at least gives people more opportunity to talk. You can maybe have smaller groups. So just really thinking about how you might manage that situation, maybe making sure that everyone puts themselves on mute and so that people aren't talking over each other, and having some sort of organised method of people sharing their views and their comments. Also thinking about costs. If people have to pay to dial into a call, they can actually potentially claim those back for you. So that's something else that you'll need to factor in. One of the questions we got asked quite a lot at the start of this whole COVID-19 situation was whether the special circumstances defence could apply. That's where in certain circumstances, it's basically really hard for an employer to collectively consult. They just can't do it. Do we think that applies here? Probably not. That would apply where there was an imminent closure, i.e. if we hadn't have got furlough, it may have applied. Because we've got the furlough scheme in place, that is buying employers time to do this. And so we think tribunals will ultimately say, you've got the time to do this, you should have done it properly. So then just in terms of the other problem area for collective consultation is if staff are on furlough, can they take part in this? Obviously staff who are furloughed aren't supposed to take part in providing any services or generating any income. The government's guidance has actually said that whilst on furlough, employees who are union or non-union representatives can undertake duties for collective consultation. So it should be fine for collective consultation. If you're wanting staff to take part in other situations like disciplinaries, etc., that is less clear cut and somewhere where you should again be getting some advice. I'm going to hand back over to Laura now in terms of just timing of redundancy and unfair dismissals.
Thanks, Sarah. So I'll just whiz through the last few slides so that we have some time for questions at the end. So even if you have a genuine redundancy situation, you still need to consider as part of a fair process if there are alternatives to or ways by which to avoid redundancy. And so the furlough scheme might be a viable alternative, but then it might not be a financially viable alternative once the employer has to start making contributions toward furloughed employees' pay. So that's just something really key to take into account there. So we do recommend you take advice, especially if you're making or you intend to make a lot of employees redundant, or if your business is unionised. And also there are some risks around what HMRC might see as a misuse of the furlough scheme. So do take advice if you're not sure, and it's always advisable to document your consideration of alternatives to redundancy as part of the redundancy process in case that's needed as evidence at a later date. The usual rules apply in respect of notice and redundancy pay. So I think the slides are again slightly behind, but hopefully they'll catch up in a sec. There we go. It's also worth noting that you can serve notice during furlough. How much a furloughed employee should be paid during their notice period is a tricky issue, and it depends on the specific circumstances. Ultimately, it will be safest to top up their pay to 100%. But again, if you're not sure, seek advice. It's not expressly confirmed in the government guidance, but if an employee remains furloughed for their notice period, you're likely to be able to use the furlough grant towards their notice pay. And the government doesn't expressly say that you can't do this like it does with redundancy payments. So we would expect that if the government didn't want the grant to go towards notice pay, then it would say that in the guidance. So as I just mentioned, the guidance does say that grants cannot be used to substitute redundancy payments. So that's just something really important to take into account. And in terms of calculating the redundancy pay of a furloughed employee, the safest course of action is to calculate a week's pay for the purposes of a statutory redundancy pay calculation on the employee's full pre-furlough salary. Otherwise, you could potentially face employment tribunal claims for the underpayment of redundancy pay. So that brings us to an end of our slides, and we've put on the slide there just a brief kind of suggested to-do list, which covers the kind of main key points that we've gone through today. It is a difficult time, and it's an unprecedented time, but it's also quite an interesting time. We're here to help businesses deal with issues arising in this context and to help them find creative solutions. So please do let us know if we can help at all. We've had a number of questions in the Q&A box. So we'll move on to those now, but before we do, I just wanted to say if you want to ask any other questions, please do put them in the Q&A box. We'll try our best to go through as many as we can now, but if not, we can always liaise with you after the webinar. And there are some links to the feedback form in the Q&A box as well, so please do take some time to fill that out before the end of the webinar. Sarah, did you want to move on to the first couple of questions?
Yep, that'd be great, thank you. Okay, so we've had some really great questions in, so thank you everyone who's asked questions so far. Please ask more. We probably won't be able to get to all of them today, but we can come back to you, and we're more than happy to talk to people outside of the webinar as well. So one of the first questions we got was, can employers force employees on furlough to take holiday at pre-allocated time? Ultimately, the short answer to that is yes. Employers can request employees to take holiday at particular times. In order to do so, you need to give them sufficient notice. You need to check your contract for that. In the absence of anything in your contract, you would need to give them statutory notice, which is double the amount of holiday you want them to take. So if you want them to take a week, you need to give them 2 weeks notice. There was some ambiguity at the start as to whether employees could take holiday while on furlough. They can. If they do take holiday, though, our view is that they have to be paid 100%. So if at the moment you're only paying the 80% under the scheme, you would need to be looked to top up. Also, you might need to think about, do you ask everyone to take all their holiday? Just that's probably not going to go down very well from a morale point of view, and also for looking after people's mental health in terms of them taking some time later on in the year. So I think just being sensible there, but I think very much employers are making sure that staff are, maybe at the halfway point of what they would have maybe taken otherwise, just to ensure that you're not at the end of the year with everyone suddenly wanting to go on holiday. And then another question I was just going to pick up before I let Laura pick up some is a really great question that we've had about how do we deal with BMI issue sensitively. So if that's likely to be, and is now one of the vulnerable groups, how do you deal with that? Because as the question says, it's clear whether someone's pregnant or not once they've told you. People are likely to identify as being Black, Asian, minority ethnic individuals, and other protected characteristics. If someone has health issues, they're likely to have told you that. But in terms of someone actually identifying what their BMI is, it is going to be really tricky to deal with. That doesn't mean you should just not deal with it. I think ultimately maybe sending guidance around to everyone to advise what the government guidance is, first of all. Probably sending the BMI calculator that the NHS has, so that people can calculate their BMI, and first of all encouraging people to come to you confidentially if they feel like they may then be in that at-risk category. If you're then finding people aren't coming back to you, or there are people who potentially you might be able to identify might be in that group, then getting some legal advice as to how to tackle that conversation, because unfortunately just because it's not a nice conversation to have doesn't mean you shouldn't have it, because ultimately there could be health and safety risks there. So I completely agree, it's a tricky one to bring up because people are unlikely to want to tell you that what their BMI is, and a situation where we could definitely help in terms of how to plan that to make sure that you're delivering the right message, but it does need to be dealt with. You can't just kind of go, that's just too horrible to talk to people about, we don't want to. So definitely need to kind of tackle that. Laura, did you want to pick up a couple of questions?
Yeah, so we have a question. Can an employee refuse to work under furlough and want to stay off at 80%? So an employee mustn't do any work while they're furloughed. They mustn't do anything which might constitute work, which might generate income for the business or any associated organisation. When we're looking at the obligation not to work, it can be quite tricky in terms of deciding what does and doesn't constitute work and what HMRC might think in this respect. So it has been confirmed by the government that employees can participate in redundancy processes, but can they participate in a disciplinary process? Can they participate in a grievance process and all things like that? So it's going to be really important for the employer to give due consideration to those points. There is some ACAS guidance on the disciplinary and grievance points, which is really helpful, and we can also advise accordingly. But I think it's just really important to make sure that employees don't do anything during furlough which could constitute work, because otherwise that will risk the grant that you receive in respect of that employee. So that's an important point to cover. Also, another question, there's a company where people are working from home and can continue to do so. If some of them request to return to the office, is this allowed, or should we tell them to stay at home? I think that's a tricky one. I think it'll be important to get to the bottom of why they want to return to work, and also risk assessments will really come into play there in terms of, is it safe for them to come back to work? But ultimately it'll depend on the specific circumstances. But as I say, risk assessments, really getting into the specific facts there will be important. Ultimately, if they're working at home, if they're being provided with everything they need, if there aren't any huge issues at home, and if they're being paid, then that should be okay for them to continue doing so going forward, if the risk assessments are suggesting that they shouldn't come back to work yet. Sarah, did you have anything to add there?
No, I think that's, yeah, entirely right. Finding out why they want to, and whether as a business you can, depending on how many people it is, you know, you might not feel in a position to do that at the moment. So I think understanding it, but if you do, you're going to need to do those risk assessments and consulting with people. So probably worthwhile putting in place your plan, because you might get more and more people asking to come back, as I think people are starting to get slightly bored with working at home. So but yeah, risk assessments really key there. We've got some other fantastic questions, but we are conscious of time, so we're very happy if people want to chat those through offline. We're very happy to talk with people, but I'll pass over to Laura just to wrap up.
Thanks. As Sarah said, thank you very much for your questions and for listening today. We wanted to say a big thank you to Hayes, who have partnered with us for the webinar today. So thank you very much to Matthew and Simon. We also wanted to just direct you to our website. So we've got a dedicated coronavirus hub on our website. So if you would like regular updates, would like to see our updated guidance and commentary, that's a really good place to look. Alternatively, please get in contact with us and we can provide you with updates, etc. And links to the coronavirus hub, which will hopefully be really helpful. Also, at the end of the slides, we have our events email address. So if you have any feedback, questions, or other topic suggestions which you'd like us to cover in future webinars, please do contact our events team and provide your comments. That would be really helpful and much appreciated. And just as a final mention, there should be a link or several links in the Q&A box throughout the webinar for you to complete the feedback form. So please do that, and then we can see you know, what your feedback is and take that into account. So we hope you've enjoyed the webinar today, and we hope you found it useful. Please do contact us if there's anything you'd like to discuss. But in the meantime, take care, and we hope to speak with you all soon. Thank you.